Good morning, everyone. I'm George Marine. I'm the Regional Director of Residential Operations with Skyline Living. I am currently responsible for the portfolio of residential operations in BC, Manitoba, Alberta, and Quebec. Currently, Skyline Living manages over 22,000 units owned by Skyline Apartment REIT across 7 provinces in Canada's secondary communities. In BC, we currently manage approximately 1,200 units, mostly in the Okanagan region as well as on the island. And I'm pleased to introduce Hunter Boucher. Hunter is the Vice President of Operations with LandlordBC. Boasting over 15 years of experience in the rental housing industry with a focus on legislative issues and best practices. We're very excited to be hosting this regional webinar today.
Thank you so much, George, for that introduction. And I see some more people have joined us. So welcome to folks who have joined us. You haven't missed any of the content of our webinar yet. We're just kind of getting introductions out of the way at this point. So welcome to anyone who's just joined us right now. Just a brief moment to talk about LandlordBC. LandlordBC is the industry leader for residential rental housing for the residential rental housing industry in British Columbia. It's our mission to support you and your rental housing business, whether you have 1 unit or hundreds of rental units, or maybe even thousands of rental units. LandlordBC prides itself on the professionalization of the rental housing industry. We do this through education, support, and of course, most importantly, government advocacy. We talk about education in this, and one of the key ways that we educate our members and the broader industry is through our webinars. So by registering for today's event, you are educating yourself, you're professionalizing yourself by getting this information. So congratulations to you, you've taken that step. And again, we welcome all of you.
So the purpose of today's webinar is to really delve into the fundamentals of successful landlording in the Okanagan rental housing market. As Hunter said, whether you're a seasoned property owner, an aspiring investor, a property manager, or a rental housing professional, this webinar will offer an exploration of residential tenancy essentials, along with valuable insights into the industry's latest updates.
Thank you, George. Yeah, so today's session, we're going to cover kind of four basic topics. I'm going to start with a bit of an industry update, where we'll talk about current state of legislation. Then we're going to talk about the state of the rental housing landscape in the Okanagan specifically. Which is important because, you know, while our legislation is provincial for the most part, I mean, the Residential Tenancy Act is a provincial piece of legislation that applies equally no matter where you are, as does many other pieces of legislation that govern our industry, including the Personal Information Protection Act, the Human Rights Code, income tax, which is obviously an important part. You need to file that when declaring rental income. While all these things are provincial, there are a lot of issues that can be very regional, and regional pressures certainly are going to have a very strong impact on rental housing. And additionally, we will talk about tenant selection, best practices, and the importance of tenancy agreements. So those are kind of our four basic topics that both myself and George will be going over today. I see a few people have just signed in as well, and will continue to do so obviously throughout the webinar. Just a reminder that today's session is being recorded, so if you've missed any aspect of today, and if you need to step away or something, that's totally fine. It will be recorded, so you'll be able to access it at a later time. It will go up on the LandlordBC YouTube. So again, just welcome to those who just joined us. So going into the topics for today, we're going to start, as it mentions, with industry updates, taking a look at what are some of the kind of driving concerns and issues that are rather current, contemporary to today. So the first thing, of course, I think that's on most people's minds is the rent increase for 2024. Generally speaking, when we talk about rent increases, there is a formula available to determine what a rent increase is going to be. And that formula equals inflation, essentially. But over the past 2 years, the government has decided to tweak that formula. And with the tweaking of that formula, we've seen a 2% increase last year, so obviously fairly low last year, and something that LandlordBC advocated strongly against, especially given the fact that what we were coming out of was multiple years of other forms of either low rent increases, so inflation was quite low for 1 year, so the increase was quite low that year, and then prior to that, of course, just all outright bans on rent increases due to COVID-19. So with that in mind, we knew that inflation for this year was going to be quite high, and the government was likely to kind of dip their hands into the regulations again and change the formula for 2024's increase, and they did just that. Welcome to those who just signed in. We started just a few minutes early because most people had already signed in. We're talking on the very first topic right now, which is the rent increase for 2024. So the rent increase for 2024 is 3.5%, and that was announced by the provincial government. Like I said, normally the rent increase percentage is done based on a formula that changes from year to year based on the consumer pricing index. But for this year, it was something that was manually set by the government, and again at 3.5%. Looking at the security deposit interest rates, well, for quite a long time, there was no security deposit amount for the return of security deposits or pet damage deposits in British Columbia. And perhaps saying no is not correct. What it was rather set at 0. So interest is still technically payable. It just was at a percentage of 0%. If you had a particularly long tenancy that went past to when interest was previously payable, then perhaps you would pay that. But with this year, we actually saw an interest rate, and unfortunately, that caught a lot of people off guard, having interest rate in 2023. But it is generally based on the prime lending rate. And of course, with the increase that we've seen on prime lending rates, it was not completely unforeseen that this would occur. As to whether or not this trend will continue, I mean, we've seen interest rates kind of hold and increase, so perhaps it will increase, and we'll have another year where interest is payable. But nonetheless, because interest was payable within 2023, for any tenancy where a deposit was held during this year, there will always be this year's interest payable on it. So that's something just to be very aware of, that because even if we have a 0% interest rate next year and the following years, this year will impact all the tenancies where security deposits were held throughout this year. So it kind of has a lasting impact. The other change, now this wasn't necessarily a change this year, but one that we want to talk about nonetheless, and that has to do with email as a method of service. Email came in as a method of service well over a year ago, after years and years and years of advocacy on part of LandlordBC to make this a method of service. The reason that we still want to talk about it is that it is a little bit of a complicated topic. It's not as simple as just saying email is now something that can be used in all tenancies. Specifically, it can be used in situations where a tenant has provided an email address to a landlord and indicated that they are allowing it to be used as a method of service. So again, it is specifically being used in situations where that email address is very clearly being provided as a method of service throughout that tenancy. And there's different ways of doing that. You can do that on the residential tenancy agreement, for example, and that's something that's on the LandlordBC tenancy agreement that we provide to our members. Additionally, it can be documented on an RTB form, and there is a specific form for that. If you go to the form section on the RTB website, you'll find a form allowing you to document that email is being used as a method of service. And the last kind of change that has happened is hearing confirmations. So this pertains specifically to dispute resolution. And if any of you have been to dispute resolution service, use the dispute resolution services provided by the RTBs, you'll know that it's quite a process. It's a fairly rigid process, and they've added something this year, which is essentially a hearing confirmation, making sure that the notice has in fact actually been served to the other party, to the tenant. Now, this isn't something that is happening on all hearings. It's kind of a bit of a pilot project by the RTB right now to see if it's going to help with perhaps maybe reducing unneeded hearings. So the idea is that they require basically just confirmation from the applicant that the other party has been served the notice of proceedings. You will not see this on every application that you make. So it's really important that when you do make an application for disposition, that you're really watching that application and that you look to see if it has that confirmation. Because if you miss it, your hearing might end up getting canceled, which obviously, if it's canceled, you're not going to resolve the issue that you applied for. So it's really important that you do read the paperwork that you get when you've made an application for dispute resolution. So I'm going to invite George to talk a little bit about the state of the Okanagan rental housing landscape.
Thanks, Hunter. So we have some data that we want to share with you today. And I will ask Hunter to go ahead and show the first slide. So let me start by disclosing that this data was provided by Zonda Urban, and Zonda Urban provides industry data for several markets across Canada. If you're interested to receive some of that information, I could also, certainly provide the contact information for Zonda Urban, or again, you can get that information directly on their website. So I do have some information that I want to share with you regarding the landscape here in the Okanagan region. And when we look at this data that we're showing right now for Q1 and Q2, this is mainly for the Kelowna markets or regions, as well as West Kelowna, Lake Country, and Beachland. Unfortunately, we weren't able to provide data for Vernon and Penticton, but these are the main markets that are included in the data I will be sharing with you today. So as you can see here, this is really for all, all rentals in the markets that I just mentioned. So Q1, they have the price per square foot, the vacancy at 10.7%. Q2, you could see that vacancy dropping to 8.4%. Seems like there was some adjustment as well in the price per square foot. Next slide, Hunter. So when we speak of stabilized vacancy, these are, rental buildings that have, or rental units that have an occupancy of 85% or higher. So in stabilized vacancy in the, 85% or higher complexes and buildings, you can see that the vacancy there is quite low. Q1, 1.3%, did jump a little bit in Q2 to 1.6%. Next slide. So again, this is average rent for the various type of units. As you can see, we have some townhomes, the active wood frame, stabilized townhomes, and then also stabilized wood frame here. So this is just to give you an idea. This is the average, the most recent information for the same markets that I mentioned, which is mainly Kelowna, West Kelowna, Lake Country, and Beachland, as there wasn't any data that was provided by Zonda for the other markets. But this should still covers a wide area of the Okanagan region. So we felt it was valuable information to share with all of you. And as Hunter mentioned, this session is being recorded, so this data will be available to you as well to review more in details. But this is pretty much where we're at in terms of average rent. The majority of the buildings are wood frame. So you can see kind of the difference here between the rents from the studio all the way to the 3-bedroom units. Next slide, Hunter. So just a couple of things to mention regarding this. I also wanted to speak about new supply. So the data that was provided to us as well was regarding new project and new supply in the Okanagan region, covering mainly West Kelowna and the Kelowna region. And the data provided is that we're looking at a total of 20 new projects, adding a total of 2,706 units. 44% of the 2,706 units being added are in West Kelowna. So West Kelowna, we're talking about new supply of around 1,195 units. And the remainder is throughout Kelowna and North Kelowna. We're looking at new supply of 874 units. Kelowna South and Mission area, 415 units. Downtown, 222 rental units, for a total of approximately 1,511. I did try to collect some data for Penticton and Vernon, the other two major areas here in the Okanagan. And Vernon, not that much new development in terms of rental. There was just a total in terms of getting the information through new permits that were issued approximately 180 units. And in Penticton, there has been some new supply, but we were not able to get the data for Penticton. But this gives you a pretty good idea that, you know, the majority of the new supply that has come on board in the Okanagan region in 2023, we are looking at mainly in West Kelowna. West Kelowna has seen a boom of new developments, and as well as, of course, throughout Kelowna. So this is just the information, kind of an overview of landscape here in the Okanagan as far as the current situation, the vacancy, new supply, and just covering some of the data that has been provided to us to share with you. As Hunter mentioned, and I'd like to welcome certainly everyone that recently joined us, but at the end it will be Q&A, so you could certainly ask your questions then, and I will try to answer as many of them regarding the Okanagan landscape. Thank you, Hunter.
Thank you so much, George. That was really great, and good to have kind of someone who is in the Okanagan, kind of feet on the ground, as it were, really being able to provide us with those details. Before we get on to tenant selection, we have a few questions for you, our audience, our attendees today, to just better understand kind of the landscape from your perspective. So what I'm going to do is I'm going to launch a poll here, just through through Zoom. It's going to pop up on your screen. If you just want to go through those questions, and we'll try to get through those kind of as quick as we can. But this gives us a chance to really kind of understand who it is that's attending this webinar, the types of issues that you are kind of facing. There'll be another survey at the end of this as well, with just a few more questions that are kind of more fill in the blank questions. So this just kind of gives you this gives us a bit of a picture of who is attending this type of webinar and the types of portfolios and such that are represented here. So just kind of going through, the first question that we have here is just how many rental units you have. So we broke it down into a few different smaller categories. We've also asked you about whether or not you own a rental unit, that you're an employee of an ownership firm, you're a licensed third-party manager, or if you're an employee of a third-party management company or other. Also just a question about income, so just trying to get an idea of whether or not this is people's kind of full-time gig, their full-time job, and then also the age of the buildings as well. Thank you. I can see people filling that out. I really appreciate you taking the time to do that. It really helps us kind of focus these sessions. We take this information back, and that's what kind of helps drive future education, both for the entire province and our kind of general programming, but also for our regional programming as well. Okay, thank you so much. I'm going to end the pool now in just a few seconds. So if you're almost... Okay, perfect. So like I said, the information that you've shared with us today is something that we will use at LandlordBC to ensure that we are providing the type of content that you're looking for. Again, there'll be a poll or a survey after this session. So when you close out of this, it'll pop up. It'll also go out in an email as well. So please fill that out. It really helps us. And part of that will be just asking what other topics you might want to hear from in the future. Again, thank you so much for sharing that information. It really helps us. Okay, so moving on, we're going to talk about tenant selection. Um, and this is kind of our part of the Landlord Basics part of today's session. Um, and uh, really, from our standpoint, from our view, tenant selection is the most important part of uh, being a landlord. It's the most important part of the process of being a landlord, because it's when you get to set up and establish a successful tenancy. It's when you get to pick the kind of right fit for your unit. And it's important to understand kind of the what goes into an effective tenant selection process. Um, so when we talk about tenant selection, um, we really want to stress that there is an importance to careful tenant selection, and the importance there is that, I think most seasoned landlords can agree that uh, it's not the easiest thing to end a tenancy and to enforce that end of tenancy, and by not selecting the right tenant for your unit, you may end up in a situation where you have to try to end the tenancy. So doing what you can up front is going to really help you reduce the risk of issues that might arise throughout a tenancy. Um, and there's things that you certainly need to consider in your tenant selection process. Uh, Primarily, what we need to focus on is things like the Human Rights Code. So if we look at, say, the Residential Tenancy Act, which is generally the document that landlords um, uh, and property managers go to for information on the topic of residential tenancies, you'll find nothing in that document, though, about tenant selection. Instead, we look at the Human Rights Code and the Personal Information Protection Act. Um, and the Human Rights Code primarily is going to talk about things that are protected. So personal characteristics that a person cannot be discriminated based on. So you essentially things you cannot say no to someone on. And those things that are protected, I think that in 2023 are generally understood by most people, though it is important that we have that code nonetheless. The things that are covered in this are things like race, ancestry, place of origin, um, uh, family status, marital status, um, age, lawful source of income, religion, gender identity, um, sexuality as well. So those, the things that, again, we generally, I think most people kind of understand that you can't, make a decision because someone is not of the same race as you, or not the same religion as you, or the same sexual orientation as you. Um, uh, so then other things that we want to look at is the Personal Information Protection Act. And what this talks about is really someone's privacy, the privacy that a person has when dealing with a landlord. And you could go to the Personal Information Protection Act and you could read that piece of legislation. Uh, you might understand how it applies to running a landlord business, though that would be rare, um, because the legislation is fairly vague and it's meant to be applied to multiple pieces or multiple types of industries all at once. Um, so instead of reading the legislation here, we actually read guidance documents that are issued by the Office of the Information and Privacy Commissioner of British Columbia. There's one specifically aimed at our industry, and it talks about what landlords can ask for in a tenant selection process. It talks about personal information in general throughout a tenancy as well, but obviously the point where a person collects the most personal information is during the tenant selection process. So that's what the majority of that guidance document is going to cover. One of the things that guidance document talks about is criminal background checks. and specifically that generally speaking, criminal background checks are not permitted. Um, and it's something that is, I think, often misunderstood um, by rental housing providers and just by people in general. Um, but it is something that is prohibited. Um, what it actually says in the guidance is that generally, no, landlords are not allowed to to run a criminal background check or a criminal record check. Now, getting into the actual process, the first thing that you really want to be sure of is that you have a thorough application form. So a thorough application for tenancy. Uh, LandlordBC provides one to our members. You won't find one on the residential tenancy branch website, an actual application for tenancy. There you will find an agreement, certainly a residential tenancy agreement. We're going to get into that topic momentarily, but not an application form. So it's important that you um, uh, that you have an application form. Again, we provide one to our members. If you go online and you Google application forms and just look for one on the internet, that's fine, but you need to make sure that it is compliant for the jurisdiction you're working in within British Columbia. Because privacy laws and such are going to be different depending on where you're running your business. So it's really important that your application form is specific to British Columbia, and of course that's what we provide to our members. Um, uh, then we have reference checks. So to conduct reference checks, you generally the tenant's consent. The best way to obtain that consent is having an application form that has a consent clause on it. So that kind of helps cover that. Again, really, really emphasizes the importance of having an application form. We then go to the next potential type of check that we can do, which is a financial background check or a credit check. And credit checks are a very very big part of the rental housing tenant selection process. Um, they allow you to kind of get a glimpse as to how someone pays their bills and the types of debts that they have, which is an important part in making your decision. Um, because while what you're doing is not issuing credit to someone, it's very similar to credit. You are providing a rental unit to someone, and expecting them to pay on a monthly basis. So a credit check is an important part of a tenant selection process. Generally, the last part of a tenant selection process, kind of once you've narrowed down your applicant base to one, maybe two people, or one or two parties. Um, Again, to run one, you need consent, which again goes back to needing that application form. Now, part of the process is also interviewing prospective tenants. You want to make sure that you take the time to actually talk to the people who you're going to be renting to. Of course, in 2023, it's really easy to have an online process where someone fills out a form, you run the checks, and you never really talk to someone. But a big part of tenant selection is kind of going on your gut and kind of getting an understanding of um, what uh, you know uh, what type of person this your tenant is, just based on conversations that you're having with them and based on the types of questions that you're going to ask. Now, the questions that you're going to ask when interviewing prospective tenants certainly need to keep things like the Human Rights Code and the Personal Information Protection Act in mind, the guidance document. So, questions to not ask, which is probably an easier thing to come up with a list of things we shouldn't ask, are going to be things like, what religion are you, for example? Well, that quite obviously is something that is likely going to lead to a complaint through the Human Rights Code if you didn't approve that person. If you ask someone what their religion is, and then you said, no, I'm not renting to you, then they have a pretty strong argument to say, well, they asked me what my religion was, and then they chose to not rent to me. I feel it's based on that. And again, that argument is strong, one, because it's a protected characteristic, but also because there wouldn't otherwise be a good reason to ask that question, which gets to the next test of kind of determining what to ask someone. The questions really need to kind of be based on suitability. So the idea here is you're trying to get to know this person based and determine their suitability for your rental unit. And so your questions that you're going to ask need to really kind of really stick to that. So, why are you leaving your current rental unit, for example? That's a good question to ask an applicant because it's related to residential tenancies, which means you have a reason to ask it. And that's generally what the Personal Information Protection Act is meant to protect, is saying, okay, you can ask questions and you can get a fair bit of information, but it's limited to what you need to know. And again, someone's religion, for example, going back to that example, isn't something that you generally need to know in renting a unit. So asking it you wouldn't really have a valid reason to ask it, and again, would likely be an issue under the Human Rights Code as well. So those are the types of questions, like I said, you want to really make sure that what you're doing is narrowing it down to things that are pertinent to your decision-making process. And then we get to the actual final decision of renting to someone or not renting to someone. And in fact, not renting to someone is something you'll do a lot more than renting to people, because the reality is, if you have one vacancy, you're likely to have, 5, 10, 15, 20, even more applicants wanting to rent your unit. So the majority of people who reach out to you are going to hear no from you as opposed to yes, because again, you only have that one unit available. So you can't provide a unit to everyone, which really means you need to get comfortable with saying no. It's important that we're comfortable with saying no. So moving on, we're going to talk a bit about the residential tenancy agreement itself, and with on the topic of the agreement, we're going to get into kind of how tenancies are established, comprehensive agreements, and so on. We'll go from there. So when we look at how tenancies are established, it's easy to say, well, they're established by signing an agreement, and that is true. But other things can establish a tenancy as well, and it's really important that we are aware of those other things that can establish a tenancy. So those other things that can establish tenancy include things like having a conversation. You can have a verbal agreement. That would establish a tenancy. It's not advisable to have a verbal agreement, obviously. We don't recommend verbal agreements, but they are nonetheless something that can occur. We'll get into kind of why they're not recommended as we talk about agreements more, but again, just on the topic of establishing tenancies, they can in fact establish tenancies. So can our actions. So we can imply a tenancy through our actions. And that seems somewhat kind of obtuse. Like, how do you imply a residential tenancy? But it's actually quite simple. The most common method of establishing a tenancy through your actions is by taking money. So if someone comes to you to apply to a rental unit and they hand you a security deposit, money that they're saying is a security deposit, and you accept it, you likely have just established a residential tenancy. And that's because residential tenancies, again, like I said, they can be established by our actions, and they define that a security deposit is something that is paid by a tenant to a landlord, which implies that a residential tenancy relationship has occurred, and you have an agreement. So it's important that when you're going through your tenant selection process, that you're really cognizant that you're not taking money from people until you're really ready to commit to a tenancy with that person. So we've covered how tenancies are established. We should look at what type of tenancy agreement you should really use. Really, what you want is a comprehensive tenancy agreement, a tenancy agreement that covers all of the kind of rights and responsibilities that you want in place during that tenancy. This includes things that potentially protect your property, but also the quiet enjoyment of other occupants of the building as well. So again, it's something that you really want to make sure that you have a kind of a thorough, comprehensive tenancy agreement in writing, because it allows you to kind of clarify those rights and responsibilities that you want to have in place. So the key elements of a tenancy agreement include things like, the basics of a tenancy agreement. So things like the name of the person the name of the landlord, the name of the tenant, the address of the renting unit, and what's being included in rent, how much rent is, and what day it's payable on. But then we get into kind of the terms of a tenancy, the rules of the tenancy. So that's when we have to talk about the type of form that you're using. You're going to use a standard form, or are you going to use something that's customized? You're going to use something that you just found on the internet. There's all different types of agreements that you can find and available. The two most common agreements in British Columbia are the agreement provided by the residential tenancy branch, and then the LandlordBC tenancy agreement, the one that we provide to our members, the LandlordBC members. And those two agreements have one thing in common, which is they include all of the standard terms that must be required in a tenancy agreement. And that's kind of an important aspect of a tenancy. In fact, it's a requirement of tenancy agreements that they include those standard terms. The LandlordBC agreement takes those standard terms and then adds to them additional clauses that help kind of clarify those rights and responsibilities further. If you're going to go online or draft your own agreement, technically that is allowed, but you need to make sure that the standard clauses are in there, but also that the terms that you're adding are enforceable. That's one of the benefits of having the LandlordBC agreement, is that we've done that work to ensure that they're enforceable as they can be, but also that they're compliant with the local laws and jurisdictions. So specifically to British Columbia. For example, if you go online, you can find tenancy agreements that are very comprehensive, but they may be focused on a completely different jurisdiction. Maybe it's outside of Canada, even, California, New Zealand, Australia. It doesn't matter. The point is, there are agreements that are available kind of across on the internet that are going to cover a broad range of jurisdictions. So you want to make sure that the one that you use is specific to ours. Recently, we ran an experiment, actually, a coworker and I, someone here at LandlordBC, to see what an agreement would look like using ChatGPT. I'm not sure if anyone's aware of it, but it's kind of an online artificial intelligence resource that a lot of students have been using apparently to write essays, but we wanted to see if it would create a residential tenancy agreement. And it certainly did create a residential tenancy agreement. But once you looked at it, you realized it didn't comply with local bylaws because the tool itself is a global tool. This is an example, though, of kind of the different places that you can go and get agreements, but need to be very wary of. The next part of tenancy agreements is making sure that everyone understands the tenancy agreement and that they consent to it. A key part of an agreement is the agreement aspect of it, the consent that comes with that. So you want to make sure that tenant, you go through the agreement with the tenant so that they understand the terms of that agreement, that they can that they comprehend the rules that they're going to need to adhere to. Because the reality is, if they can't understand, they don't understand the rules, then how is it that they're going to actually, adhere to them? So again, we want to make sure that it's clear that your tenant has understanding of the agreement, and that's as simple as just sitting down when you're going to sign the agreement with the tenant and going through the clauses, and if they have any questions, answering those questions. So that finishes our kind of presentation here, our prepared slides. I want to thank everyone for your attention during the presentation. And again, as mentioned earlier, the session has been recorded, so we'll get the recording up on our YouTube. But additionally, we'll now get to Q&A. So if you have any questions, please feel free to drop the questions in the Q&A. And we will start getting to those kind of momentarily as those come in.
Please don't be shy if you need further clarification on what Hunter or myself covered today. This is the time really to then take the opportunity to ask any questions or any further clarification.
Yeah, so it looks like some questions are coming in now, so great, thank you so much. George, are you wanting to?
Yeah, I can go over that. Let me just open my. So the first question was just to ask if you will be sharing the results of the poll taken today, Hunter.
Yeah. So we're gonna review the information that we've shared. It's generally used for internal processes only. None of the personal information will be shared, certainly.
Okay.
So if there was any personal information shared with us, we don't share that at all. But yeah, let's see if we can actually show the results.
Yeah, and of course that will be based on the individuals attending our session today. So
yeah, and actually, I'm comfortable sharing because there is no personal information shared in this. I can share the results of the poll that we ran earlier right now.
Sure. Yeah, why don't we do that?
I'll just show that on the screen right now. You should now be able to see the results there. That gives us an idea of kind of who's attending. And it's important for us to kind of understand things like portfolio size, for example, knowing that, the majority of the people attending, what type of, how many units you have, or roughly how many units you have. And also understanding, are you an owner or an employee of an owner versus a property management firm? Those are the sorts of things that become really important for us. Also understanding whether or not this is kind of your primary job, or if you are also perhaps being full-time or part-time employed. And of course, understanding the age of the buildings as well is also really important. And it looks like based on the age that actually a majority of the buildings, have been that are being represented here by the people who are here today, are, about less than 20 years old. Um, so
Sure.
that's going
Yeah.
to again help us kind of inform us on the types of topics that we want to focus when we try to do this sort of regional education again.
Okay. Next question is from Gary. My tenants have a provincial contract with an addendum that includes picking up their dog feces. This isn't being done and is becoming problematic. What do I need to do to enforce this? Tensions are building. Are there any restrictions on how close to the residence that the tenants can smoke tobacco or cannabis? No
Okay,
smoking is allowed
so
in the
it sounds like
residence.
maybe there's a couple questions
Yeah,
there.
yeah. No, I'll let you
Maybe
answer.
maybe let's that's good. So maybe what we do is let's look at this first one. So you said the situation here is that we have a tenancy where we have the provincial contract, that standard agreement, with an added term that the tenant would pick up after their dog, and this of course is not being done. Um, and as the question, the person asking it has stated, tensions are building on that. So um, you know, this sounds to me like this is a term of the tenancy agreement. You've written this into the tenancy agreement as a term of that tenancy, which um, uh, when we have a term of the tenancy agreement, if the tenant is not complying with it, that's a breach of a term. Um, and breaches of the terms can be dealt with ultimately with an end of tenancy. But before we get to an end of tenancy, um, we uh, we really want to make sure that that we're communicating with the tenant, that that we're giving them a chance to resolve the issue. This is true because of two things. One, because we want to do what we can to preserve tenancies and resolve issues without disputes and such. But also because the Residential Tenancy Act kind of requires us to, if we're going to go the route of ending a tenancy. So, generally the process would be having a conversation with the tenant, perhaps documenting it, a friendly reminder saying, hey, this isn't being done, it needs to be done. Please make sure that you are picking up after your dog. Um, Now, if uh, this is still not being done after you've had that conversation, we then have to look at something a bit more official. Um, and that's where a caution notice become handy and really the next step in the process. So a caution notice informs the tenant what an issue is, how to resolve the issue, and when to resolve the issue by. Um, and so again, three primary things it informs the tenant: what the issue is, how to resolve it, when to resolve it by. It also should state that if the tenant doesn't comply, their tenancy may come to an end, that it really will come to an end. This is a really kind of strong stance to take, giving a caution notice, because you are stating that the next step is a notice to end tenancy. Very clearly, it will be a notice to end tenancy next. So you don't really want to give a caution notice until you are comfortable that the next step for you is that you're giving this notice to end tenancy. But once you get to that point, most certainly, and we provide a template for a caution notice on the LandlordBC website.
Yeah, thanks, Hunter. And just to emphasize what Hunter said, documentation is critical. It's important that you document conversation, emails, any other documentation that you have will really help support your case. So that's the key, documentation. The next question was, are there any restrictions on how close to the residence that the tenants can smoke tobacco or cannabis? No smoking is allowed in the residence, but I have personally smelled fresh smoke in the residence. How can I get out of this tenancy?
Yeah. So, I mean, when it comes to restrictions about how close to the residence the tenants can smoke tobacco, it really comes down to the tobacco or cannabis. It really comes down to um, your tenancy agreement. Um, for example, the LandlordBC tenancy agreement says that they cannot smoke in the rental unit or on the residential property. So they would have to actually go off the property to smoke. Now, if your agreement just says, you can't smoke in the unit, and it doesn't say anything about the residential property, then it's possible that they can smoke on the residential property. And with that, that might be a valid thing that they're doing. Whether or not they should smoke or not is another question, but that certainly is something that is really comes down to the wording of your agreement. Now, what we're talking about is that they're off the property, but they're not very far from the property. Maybe the property has windows that are right on the property line, for example, with the sidewalk um, right below. Well, then you'd want to look at kind of what your local bylaws say about that. If they have anything around kind of private property and smoking bylaws, um, that might be something that you can address that way. That's a difficult one to address though, because at that point, one, you're gonna have to go out and kind of measure, make sure the person is actually within that distance, but also because at that point we're talking about public space. It becomes kind of questionable as to whether or not the Residential Tenancy Act can even apply in that case.
Yeah.
So again, we really want to make sure that the agreement is thorough. Now, regardless of whether the agreement is thorough or not, it may also be addressed through things like whether or not it's disrupting the quiet enjoyment of other folks as well, and that's a very real kind of concern that people have, and one that can be addressed that way as well.
Just to add to what Hunter said, in terms of best practices, again, it's very important to ensure that it is stated in the tenancy agreement that non-smoking is not permitted in the residence or any other areas that you do not allow smoking. That's very important. Another best practice or certainly advice I can give you are all our skyline properties and residences are all non-smoking, and that's clearly stated in our tenancy agreements. But however, what we do, because we do know that we have certain tenants that smoke, is that we do set up designated smoking areas around the complex, depending the size of the complex. But we do, as a courtesy to the tenants, we'll designate a smoking area, provide what's needed in a smoking area. And we remind them again that this is the designated smoking area, that smoking any other area or on a patio or inside the building, common areas, residence is not permitted. And of course, then what we do, since it is in the tenancy agreement, then as Hunter said, we proceed with, verbal conversation with the tenant and then escalate those notices if they continue to do so, as it is a breach of their tenancy agreement. Next question is, what about midterm and short-term agreements?
Yeah, so the topic of midterm or short-term agreements, really we have two things. We either have a residential tenancy, which is generally considered long-term, and that's any tenancy where what you're doing is renting a space for someone to live as their home, and that might be a couple months, that might be several years, and maybe decades even. So most things that we're talking about here, or all things that we're talking about, are going to be residential tenancies. Then we get short-term tenancies, which don't really exist as a term. I mean, the idea of a short-term tenancy um, as an actual term that exists in the legislation or something like that doesn't really exist. So what we have to determine is it perhaps maybe vacation rental? In which case, if it is, accommodation that is provided for the purposes of vacation or travel accommodation doesn't fall under the Residential Tenancy Act. But basically everything else falls to the Residential Tenancy Act. So looking at the Residential Tenancy Act, and specifically looking at how do we set up terms, whether it's short, mid, or long-term tenancy agreement. Well, we look at the very beginning, kind of with the tenancy agreement, where it talks about the length of the tenancy. And when it talks about the length of the tenancy, you can establish that a tenancy will end at a specific date. And so that could be, 2 months from the date the tenancy was entered into. It could be 6 months. It could be a year. It could be 2 years. But its use is very, very regulated, and can only be used when a landlord, an owner, is intending to move in to the rental unit, and occupy it. And it's the owner or the owner's close family member, which is defined as a parent or child of the landlord or of the landlord's spouse. So again, the idea here is that you can have a fixed term tenancy that says the tenant can leave, and that could be, a 3-month fixed term, but it must be used in those very, very specific situations. And in those specific situations, again, it's well documented, it's initialed by both parties, and the landlord would then have to use that space for at least 6 months for that purpose. So they can't just say, I'm going to move in and stay there for a couple of weeks and then move out. They have to actually use the space and occupy it, and live in it, really, use it for residential purposes for at least 6 months.
Okay. Next question, if I do my own repairs that the tenant caused damage, can I invoice against the damage deposit for it?
Yeah, that's a really good question. And it's one that's somewhat split at dispute resolution, but generally speaking, the answer is yes. If you take the time to conduct repairs and maintenance to your unit, and the damage was caused by the tenant, that may make up part of the debt that you end up wanting to apply against through the security deposit. What you need to do is come up with an hourly rate that you're going to charge the person for your work. That amount is really the part that kind of catches most people and is really the kind of debatable part at dispute resolution. It's different kind of depending on the arbitrator that you're dealing with. I've seen it, but be around $25 an hour, sometimes 30, 35, up to $40 an hour. So it's kind of, now if you hire a professional to do the work, well, then you're just passing on whatever invoice you get for that, so whatever hourly rate they charge. But certainly it can be something that can be used against the security deposit. Now, I should note as well that if we're talking about deducting from the security deposit, there is a process for that. There's always a process for dealing with security deposits, and we need to make sure we're following it, because if you don't follow it, you might end up having to pay double the deposit. So while the debt itself might be valid, we need to make sure we go through that process. And that's either getting the tenant to sign something saying they agree to that deduction, or applying to the residential tenancy branch to retain that amount.
Absolutely. Next question. What if my tenant won't sign an updated agreement? Oops, it just moved here. Oh, sorry, let me go back. Moved here. What if my tenant won't sign an updated agreement? He signed one 4 years ago. He won't respond when I ask for a new updated one. Is it critical?
Yeah, that's a really good question. Um, so, uh, generally speaking, once a uh, a, a, a tenancy agreement is entered into, um, it's the document for the life of that tenancy until the tenant actually leaves. Um, there are certainly situations where new agreements might come in during a tenancy, but generally not. It's definitely not the norm to sign new tenancy agreements while a tenant is still in a unit. Um, so, with that in mind, you don't have to get new agreements signed. The terms when if for example you had a tenancy agreement that was for a fixed length of time, and at the end of that time the tenant simply stayed in the unit, paid you rent, and you accepted it, and such, the tenancy simply just continues then on a month-to-month basis. So that's what you have in this situation, is you have a month-to-month tenancy. The tenant is under no obligation to sign another agreement um, once they've entered into the original agreement. Um, so there's really nothing from their end that would likely benefit them to do so. So they generally won't. Um, uh, So yeah, I think that generally kind of, like I said, is not a requirement to sign another agreement, and it's also really not advisable to sign another agreement partway through a tenancy as well, because if you sign another agreement, kind of partway through a tenancy, we've now you know we now have another agreement as part of the paper trail, uh, which can get confusing when dealing with things like, when did the tenancy really begin? When did you take the security deposit? When was the condition inspection report done? Which version of the agreement is currently in place. Um, those are all things that can kind of cause issues for you.
If someone is, next question, if someone is signing a lease for less than 1 year, does it fall under the RTA?
Yeah, that's a really good question. So if you're signing an agreement that is less than 1 year, is it a residential tenancy agreement under the Residential Tenancy Act? Um, and potentially, you know, in those situations, maybe not even using a standard RTV form. Um, the answer is yeah, it likely is still a residential tenancy. The agreement you use and the length is generally not what establishes if it is in fact a residential tenancy. Um, the uh, what establishes a tenancy is kind of, well, there's the saying, if it walks like a duck and it quacks like a duck, well, then it's probably a duck. Um, and residential tenancies kind of take that to heart. It's if it looks like a residential tenancy in that you as a homeowner or apartment manager have a rental unit that you are providing to someone and you are taking money in response to that, well, that right there sounds like a tenancy, and that it's clear that uh, that it is not um, intended for the purposes of vacation rental, uh, then it's going to likely be a residential tenancy. Um, and that's regardless of the length of the term, generally speaking. Um, so so we kind of have to look at that maybe from a different perspective too. We can look at vacation rentals. How do we know if it's a vacation rental? Well, we know it's a vacation rental generally from a few points. One is how long that term the stay is. So generally, vacation rental is going to be a few weeks, a month. It's not to say they can't be longer, and they certainly can. Um, so other aspects are the type of communication that's used to establish that that stay. Was it done through something like, say, Airbnb, um, or Verbo, or whatever service people might choose to use? And is it clear that the communications from both parties that it was obviously meant as vacation? Which means that you have to be careful with offering vacation rental, because if you offer vacation rental, and you let someone in there and live there for maybe 3-4 months, and that they're using it as their home, not as temporary travel accommodation, that might then start walking and sounding like a duck, like a tenancy. So we have to there is a lot of kind of gray area there, but also just kind of comes down to, what does it look like? What does it sound like? If it looks and sounds like a residential tenancy, it probably is.
Okay. Next question here, comment. Sorry, missed first part about email used for serving documents. Can the clause be included in the tenancy agreement, or do we have to use the tenancy form for this purpose? So if there is a document, I'll let Hunter respond.
Yeah. I mean, you can use the tenancy agreement, or you could use the RTB form for this.
Yeah.
Either a or you could actually use your own form, to be honest. The reality is, when it comes to this specific topic, we're talking about email as a method of service. So long as you have something that clearly documents that the tenant is providing the email address to be used as a method of service, that's the important aspect of it. So the LandlordBC agreement meets that. The RTB form obviously meets that as well. But if you had your own form, that would be fine as well. The point is, it just has to be really clear that it's being provided for that purpose, not just provided as an email address. So you can't just put a field on the application form that says email address and that's it. It doesn't talk about it being used as a method of service. It needs to actually be provided and indicated that it's being used as a method of service.
And just to piggyback on what Hunter said, as best practice, what we do with Skyline Living is we actually use that form and have the tenant sign it or not sign it, but we do present that form at the time of the signing of the tenancy agreement. So it's a good best practice. Just have that document. They're meeting with you, they're signing their tenancy agreement, and at that time you can present that document and they can sign it, so you put it all together.
Yeah. So I think we have a bit of time to get to a few more questions.
Okay. Yep. Yeah. So just one here. Have you a sense, opinion of the impact that short-term accommodations have had or is having upon rental rates and availability? I mean, I have an opinion. I don't have any data, but certainly there's been a lot in the news about the increase of short-term rental, especially in BC. But yes, the answer is that I don't have any exact data, but it does have an impact in terms of the supply. So certainly when those units are used for short-term rather than long-term rental, then of course that diminishes then the supply that's available in the market for long-term rentals. So that again, it's supply and demand, so that would impact the rates, but it does impact availability for sure. It does have a greater impact on the hotel industry, more so than the rental industry, because then if people are choosing short-term rentals over hotel rooms, it impacts negatively their business. But for us, in terms of rental, yes, the answer is, in my opinion, does have certainly increases. It increases the rates based on the fact that the availability is much less. Hunter, I don't know if you want to add anything to that.
Yeah, certainly. I don't have any stats specific to the Okanagan, though I can say that if you go online, you can clearly see no shortage of Airbnb listings for the Okanagan region, which is obviously going to have an impact on rental housing. The reality is that most of these Airbnb units, when you go and you see, they are private residences. They're not, a room in someone's house. They're not kind of the traditional B&B type format. They are separate, kind of they're units that have been designed to rent it out like this on a short-term basis, which means they're taking away from the rental stock.
That's right.
And really during a rental housing crisis, it's something that any reduction of rental housing stock is impactful. Um, so uh, that's something that um, is really um, uh, you know it's a negative impact on the industry overall because it's not it reduces supply, and reducing supply at this time is causing undue stresses on the overall rental housing landscape, and something that really needs to, in our opinion at least, come to an end. We've not been shy on that part. Um, so I think there's one more question um, that I want to get to here, and it just has to do with um, uh, uh, the um, uh, kind of Personal Information Protection Act. Um, it says that why can't evictions be announced by previous landlords to protect future landlords? Why do privacy laws protect eviction status? Um, well, in British Columbia, they don't. Uh, you know, the 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 reality here is that in British Columbia, privacy laws allow landlords to check references, and one of the things that they can check when asking is, why did this tenancy come to an end? So it's pertinent to their 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 purpose of checking references. Um, so it is something that can in fact be asked, um, and it's something that technically can be answered as well. The problem that people run into is not so much around the privacy law and more around um, uh, you know, the possibility of someone saying, okay, well, you said this, that's slander, uh, and because I didn't get this, I'm holding you liable for not for not getting this rental unit. Um, so you know, I think that's a fear that a lot of people have when it comes to providing references. Um, it's not so much again the privacy legislation; it's more, I think, a fear that someone might come back with some sort of civil suit saying that there's slander. Because again, the privacy guidelines don't talk about that at all as being something that can't be answered or asked. Now, that being said, the other part of it is quite often people who are getting rid of a tenant that they don't particularly didn't have a good experience with, uh, are often motivated to ensure that they find that tenant finds a new place to live, uh, because they then become not their issue. So you have to be kind of careful with using um, current landlords at least as references, um, because the veracity, the accuracy of that is not always clear. So I think that is all the questions or time we have for questions here. I see a few more questions come in. We'll try to get to them perhaps maybe in a follow-up email. Um, really thank everyone for your attention today, for your time. Um, Thank you, George, so much for hosting this and suggesting that we reach out to the Okanagan. We're really excited that we're able to kind of do these very focused um, sessions and really kind of ensure that um, our members in the different regions of the province kind of get that tailored information. It also helps us, like I said, we gathered some information here. We're going to gather some more information in a survey that'll pop up when you leave the webinar. Um, please answer those questions because it helps us develop future content and potentially, coming to you in person um, in the new year as well. That would be ideal for us as well. So again, try to get to if you can, please answer the survey questions at the end. And thank you for attending, and thank you, George.
Yeah, well, thank you everyone for taking the time to attend. Thank you, Hunter. I do want to say that someone had a comment there, Hunter, that said, I really appreciate this webinar today, but are there any plans to have one in person? So I would let you speak to that.
Yeah. Well, we are certainly always talking about how we want to get to the Okanagan that we have in the past. So I think there certainly are plans in the new year to travel to the Okanagan, and this is actually this was a bit of a kind of fact-finding mission for us on that as well, to try to understand some of the issues that that landlords in your region are facing. So thank you.
Great. Thank you, Hunter, and thank you, everyone, once again.
Perfect. Thank you.